Hello everybody, welcome back. This is Neil back in my favourite place, Waterford. Today we're diving into the three concepts that decide the fate of every courtroom battle: relevance, admissibility and weight. Yes, three little words with the power to make or break a case and occasionally make a barrister cry. Now let's start with the big one, relevance. Good old J.F. Stephen, who wrote about evidence law back when everyone wore hats and pretended to enjoy cod liver oil, said that two facts are relevant when one makes the other more or less probable according to the common course of events. Gulp, nice one, J.F. Let's think about that for a minute. In other words, if fact A makes fact B more likely, congratulations, you've discovered relevance. If fact A tells us absolutely nothing about fact B, then fact A can wait outside on the naughty step like a bold child. Relevance is all about connections. It is about helping the court answer the questions that the trial has thrown up. We call these questions the issues. The judge asks, does this piece of evidence help me answer one of the actual issues in the case? Or is it just something the lawyer found while rummaging in their attic? And here's the important bit. Evidence is relevant to something. You can't say, this is relevant, without adding the all-important follow-up. Relevant to what? To decide relevance, courts rely on logic, common sense, and human behavior. For example, if the prosecution wants to prove someone had a motive for murder, they can't stick a camera inside the suspect's brain. But they can show evidence of fights, threats, or long-standing hatred. If we were to put that in a syllogism, that's your word for today, look it up. Major premise: most murders are driven by motive. Minor premise: the defendant and the deceased hated each other. Conclusion: the defendant had motive. The minor premise is the admissible evidence because it tells us about something the court needs to answer. Did the defendant have motive? And remember, evidence is often relevant because of other evidence already given. Relevance means the evidence helps prove or disprove an issue. So, your first key principle. All evidence must be relevant to the issues before the court, which are, in turn, determined by the facts in issue, which are the facts in dispute between the parties that must be proved in order to succeed in a claim before the court.
Next up is admissibility, the doorway through which evidence must pass before the court is allowed to consider it.
The first thing to understand is that Ireland and many other countries have what is known as an exclusionary system of evidence. What that means is that evidence stays outside the court until it is admitted. If any evidence is not admitted, in other words, it is declared inadmissible, then in an ideal world, the people inside the court will never know of its existence. This is very important where there is a jury, as it means, ideally, the jury will never know about evidence that was ruled inadmissible because it was irrelevant or illegal. This prevents what is known as contamination of the jury. For example, if the prosecution wanted to admit evidence of a confession, but the judge disallowed it because the prisoner was tortured. If the jury heard that there was a confession, they might never get that fact out of their heads, even when they hear about the torture. So, it's best they don't hear about it at all. In this age of social media, it is often a challenge to prevent the jury from hearing about something that they should not know about and thereby becoming contaminated. The trial judge is effectively the gatekeeper of what is allowed into court and what is not. Evidence that the trial judge allows into court is admissible evidence, and evidence that the judge keeps out is inadmissible evidence. The question of admissibility is therefore a question of law, and as such is the sole responsibility of the trial judge. ideally, the jury should have no knowledge of the details of this process. So, your second key principle: evidence is admissible when it can be properly received by a court as a matter of law. As the question of admissibility of evidence is a question of law as opposed to fact, it is decided by the trial judge and not the jury. Now, here's a brain tickler. Irrelevant evidence is always inadmissible, but not all relevant evidence is admissible. What? Actually, it's not as crazy as it sounds. What this means is that if evidence will do more harm than good, the judge can exclude it even though it is relevant to the issues, usually because it's unreliable, unfair, or impossible to test. Similarly, if the reception of a certain type of evidence will set a dangerous precedent, then the judge can exclude it, even though it is highly relevant. For example, a recording of an incriminating conversation which was obtained as a result of an illegal telephone recording, often called a wiretap. If the jury heard the recording, they would almost certainly convict. But to allow an illegally obtained recording to be admitted would be creating a very dangerous precedent, as it would give the police a free ticket to gather illegally obtained evidence. And finally, weight. Not the kind you worry about after Christmas. We're talking about persuasive power. Once the evidence is in, once it's relevant and admissible, the fact finder asks, how convincing is it? This is a measure of just how useful an item of evidence is. By that I mean, how useful is that evidence in helping the jury come to the right decision? Admissibility might win you some battles, but weight wins the war. Another name for weight is probative force. How much does that evidence help in determining the truth? For example, imagine an eyewitness swearing they saw the defendant clearly, but then under cross-examination they admit terrible eyesight, bad weather, and a lamppost blocking their view. Relevant? Yes. Admissible? Probably. Weight? Like a feather in a hurricane. And that is why weight wins the war. You can get your evidence into court, but it is the quality of your evidence that needs to impress the fact finder. This will include things like how well your witness speaks, how clear are their explanations, how convincing are they under cross-examination. This is known as the demeanor of the witness. In other words, it is relatively easy to get a witness into court, but it is the performance of that witness that can turn a case. So, your third and final key principle for today. The weight of the evidence is the probative force of the evidence. It is a measure of the contribution the evidence can make to resolving the facts at issue or to proving the fact or facts that it was led to prove. This is a question of fact, and so will be decided by the jury in a jury trial. So, here's the triple crown of evidence. First, relevance. Does it help answer the questions before the court? Second, admissibility. Is it legally acceptable to allow that evidence into court? Third, weight. How convincing is it? Master these, and you'll understand how courts sift truth from nonsense. I'm Neil, and I'll see you next time on The Law is My Oyster. This video was written, directed, and produced by Neil Van Dockum, who asserts copyright over its contents, as contemplated and protected by the Berne Convention.